Hi, everyone. Harry here, back on the landscape of law firms and what's going on there. Recall, Trump has tried to bully and browbeat a lot of different law firms. Some of them capitulated, others did not. One who did not is the Jenner Block law firm. Trump went after them as he's gone after many firms, really for stated reasons of, oh, they have DEI policies or they're not diverse in the work they do. Total crap because A, it's a pretext, and B, they're perfectly allowed to represent whom they want. Nevertheless, he went after them, and you recall we had a couple big ones like Paul Weiss capitulate at first, and Jenner is one of the two big ones that pushed back along with Perkins Coie. Perkins Coie has won a significant case in the DC District Court. Judge Beryl Howe, that's on appeal, and now the same with Jenner and Block. Why did Trump choose Jenner and Block? I mean, it's really clear. It's hardly even camouflage. Jenner and Block had the nerve to employ Andrew Weissman for a brief period of time after Weissman left the Mueller probe where he played a significant role. So literally, that's the reason he wants to totally cripple a law firm, bring it under his thumb, obviously create all kinds of economic inefficiencies and problems for potential clients. So when Jenner Block came in, they really had many, many claims of unconstitutionality, including vis-a-vis clients who don't get the lawyers of their choice under the way Trump wants to work it, but their own violations of due process and simply just, hey, there's no executive power to do this, just ultra vires, as the law would put it. Okay. Judge John Bates, a George W. Bush appointee, got the opinion and issued it 2 months ago. And let me just read the beginning, and you can guess from hearing it who you think is going to win. In our constitutional order, few stars are as fixed as the principle that no official quote can prescribe what shall be orthodox in politics. And in our constitutional order, few actors are as central to fixing that star as lawyers. This case arises from one of a series of executive orders targeting law firms that in one way or another did not bow to the current presidential administration's political orthodoxy. So that one, in one way or another, puts it out pretty clearly. We know what's going on here, says Judge Bates. They're doing this for political reasons and really kind of petty ones that just have nothing to do with A, what they're saying, but B, any plausible actual grant of power. Now, he lays this all out, and there are many different constitutional claims, and he grants several of them. There are others that he says have to wait for another day, and others still that he says have not yet ripened. Jenner in there says, look at all these reprisals that he's going to do. But if there is in this sort of whole welter of constitutional claims, one in particular that he thinks is the animating principle, that is the judge, it's you cannot suppress the speech of someone based on a reprisal for the speech or conduct that they have had. So in other words, law firms have free speech rights. They have a lot of rights, and their clients potentially do as well. But what Bates is really finding is you are just coming after them in reprisal or revenge for things they've done that you don't like. That is really about the highest kind of burden for the government to try to discharge. And Bates makes it clear, no way did they do it. Okay, so that was, it's a scathing opinion, one of several in the law firm area that really takes the administration to task. Now, it happened 2 months ago or 60 days ago, which is the actual time limit, absent an extension, for the government to bring an appeal. And that's kind of interesting. Typically, and all they've done here is preserve their appellate rights. They've just filed a piece of paper that says a notice of appeal. They can withdraw that at any time. But we see how this administration works, including in some law firm cases. They immediately rush in seeking emergency review, and the republic will fall unless the Court of Appeals or the Supreme Court completely reverses what a district court has done. So here, obviously, there's been internal debate, and the fact that what was filed was the mere piece of paper that you check and say, I'm appealing, to me suggests that they haven't decided to actually make an earnest go of the appeal. And why wouldn't they when they've done it elsewhere? And it may be that, of all things, this administration is beginning to understand the so-called rule of holes. When you're in a hole, stop digging. It's such a weak and such a clear pretext. They purported reasons for doing this to Jenner Block. Basically, they want to just gore them because they once employed a perfectly competent, and more than competent, and a great lawyer coming from the Mueller probe. So it's just a case that the Solicitor General, who makes all the decisions about what to do on appeal, has just decided, man, you're giving me some hard ones, but this one, there's just no way. So we will see whether this notice of appeal eventuates in an actual appeal and briefs and the like. For now, all they've done is, preserve their options. And that itself, that it takes them 60 days and they only preserve their options, is the sort of intriguing headline of this notice of appeal, because it suggests a fair bit of internal debate, reflection, and awareness on the part of the DOJ of how much they have harmed their reputation with the courts, with appeal after appeal and terrible legal position after terrible legal position. And they may be actually trying to regain some measure of institutional credibility with the courts, and in particular the DC Circuit. And that's who this appeal would be in front of. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.